Good evening and welcome to the Private Property Podcast, where we provide you with valuable knowledge and information on all things property related. Whether you're a first-time home buyer, a seasoned investor, or you're just looking for some expert advice, we have got you covered. All you have to do is tune in every Tuesday and Thursday at 7 p.m. for tips, insights, and expert advice on burning topics related to property, because this podcast is brought to you by Private Property. And remember, you can find your new home on privateproperty.co.za. Welcome to the Private Property Podcast. On tonight's episode, we'll be unpacking exactly what you need to know about the condition of a property before signing an agreement. Joining me in studio to discuss this interesting topic is Associate Attorney, Notary Conveyancer Matome Mathseta from Adams & Adams. But before we dive into that conversation, please remember to comment below and share your thoughts about today's show. You can join that conversation by using the hashtag #FindYourNewHome on privateproperty.co.za and hashtag the Private Property Podcast on all social media. We'll be keeping an eye out for your posts, and we may even feature some of your comments on the show. Because this is the Private Property Podcast, where we provide you with valuable information and all things you need to know that are property related. Like I said before, I am not alone in studio, so let's get into it. First, a disclaimer. My producer gave me a research pack for today's show, and I was supposed to read it, but I got caught on one thing, and perhaps you can help me with this. What is a footstool? First of all, welcome. Hello, welcome.
Hello.
It's nice to have you.
Yeah.
How are you?
I'm fine. How are you?
Compliments.
Great.
Let's get into it.
Yes.
What is a footstool?
Yeah, well, footstool, it's a common law principle adapted from a Roman Dutch law. But what it basically means...
Roman Dutch
law. Remember, we were colonized, and part of our law is a Roman Dutch law, and we also have English law. Together, they are common law.
Okay.
So hence we say it is a part of common law. It's a common law principle, so to say. But what it actually means is that you are buying the property, in our instance, in its current conditions, meaning as it stands. The seller is selling that property to you without any warranty, without any guarantee. So you're buying it at its current state.
Okay, so I'm Sibs. I now have enough money. I'm going to go and look for a house. Or if I go and then I see like there's a crack in the wall, maybe there's some leakages, there's strange things that I want the owner to explain before I buy this thing. Like, is he going to do anything about it?
Yes, that's an important question. So food stores, the very same principle of food stores requires the purchaser to go to the property prior to them signing an offer to purchase or sale agreement, which I would say, to inspect the property and make sure that the property, it is in a satisfactory state before they can conclude an agreement. So the moment you find out that there are cracked walls and all sorts of things, then you need to say, I'm not taking it, or I am taking it, but not at that price, because I think this is now, it's more expensive compared to how it actually looks, you know?
Okay,
Yeah.
Because I was going to ask, under what conditions do people now agree to this thing?
Yeah, well, they do, especially investors who look at the property and see potential of it being usable after renovations.
Like a fixer-upper or a flip?
Exactly. They say they flip them around. So yeah, they still buy them as they are. You usually see this in auctions because normally houses you buy on auctions wouldn't be in the very right state. Not that all of them would be like that, but usually you find those, and that's where food stores get to work a lot.
Okay, cool. So now you've said I must go. It's up to me. It's my responsibility to go to the food stores place and do an inspection and see all of the things that need to be done.
Precisely.
Okay, fine. And then I make an offer to purchase, and then I buy the place.
Correct.
So now I must pay to fix all of those things. That's what you're saying.
Because you are fully aware of them before purchasing. Yes, so that is what food stores is saying. The seller is giving it to you without any guarantee, without any warranty. the property is being sold as it is.
It sounds like I'm being scammed. Why do I feel like I'm being scammed?
You're not necessarily being scammed. Hence, you're given an opportunity to come and inspect the property. But you having said that, some of the sellers can be a bit dodgy. Upon your inspection, it's not everything that you are going to be able to identify. It might be a faulty plumbing. That you can't see with your naked eye.
Yes.
But now, the very same principle of food stores requires the seller to disclose those defects. They call them latent defects, the defects that would ordinarily require an expert to be able to identify, because you can't, and that is when then they are required to disclose those latent defects, to say, hey, over and above what you have seen in this property, there is a faulty pool pump, there is a raising dam, there is a leaking roof. Because that will only see during rainfalls.
Absolutely.
If you're buying in winter, you won't even see the marks. Some of them go to an extent of repainting the walls
to
cover
pretend,
up,
yes,
to cover up the marks before you can go to the
scam
property.
artists.
Yes.
What recourse do I have now? These latent defects that you're talking about, that they are supposed to disclose, legally obligated actually to disclose.
Yes.
Someone doesn't do that, or they cut corners, or they paint over the marks on the walls. What recourse do I have now as the buyer?
Exactly. You can use the very same food stores to sue them and recover whatever money that you are going to spend on fixing whatever defects that would be there. So remember, food stores is presumably working for the seller, meaning it protects the seller. So it says that the seller cannot rely on the principle of food stores if they deliberately concealed the defect, even though they had the duty to disclose them. You understand?
Yes.
So you can say, no, you cannot be protected by food stores. I am going to sue you. We have got cases like those where the purchasers actually get to back some money back.
How much?
It depends.
Like, how long does that take? How long does it take to sue someone?
It takes forever. It takes forever. There's a judgment actually which was passed early this year. I can't remember precisely how long it took, but it's long enough. I think it was over 5 years or so.
What did the scammer try and scam?
Yeah, look, in that case, I can't remember the details quite vividly, but the purchaser went to inspect the property and saw a raising dam on the wall. And what happened subsequently was that, look, the seller said, it's only here. I would fix this one. And it was fine. He said, no, good. And that was fixed. Now, fast forward, the deal is concluded, registration takes place, and the purchaser, before moving into the property, or rather, just after moving into the property, she then locks it up and goes for holidays. It was around December. And when she comes back
to her brand new house
in January, she finds out that the raising dams are now showing almost all over the property.
Oh my gosh.
And she was so surprised. But now that was self-evident that the seller knew about those raising dams, but they did not disclose them. And probably they even covered them up, or they couldn't show at the time of inspection because maybe it was not raining. And now that it rained, maybe it was during festives and it's summer. So they were now showing, and it went to court. And I think the judgment said that the purchaser must be reimbursed around 400K. I can't remember vividly how much the purchase price was, but it was quite a good money that she got
a significant
back.
Amount.
Yeah, to fix those defects and stuff like that.
Now you can extend your house, just
mostly it will be to fix whatever damage that is on the property,
Yeah.
Because the code, I suppose the court will then look into
what's fair,
what's fair,
yeah.
And is this a reasonable code and stuff like that. So yeah.
Okay, that makes sense.
But that is not advisable.
Oh.
Because it takes forever. Hence, the law introduced a better mechanism in terms of Section 67 of the Property Practitioners Act.
What does it say?
It says that before a property practitioner, being an estate agent, can seal a deal with the seller, you are the seller. You say, I need to sell this property. You, estate agent, come and I'm going to give you a mandate to go and market this property. Before that estate agent can accept that mandate, they must conclude, or rather complete, the mandatory disclosure form, whereby the seller is going to be detailing all the defects on the property, so that when this person goes out to market, the estate agent, they are marketing the property with all the defects detailed
as it is.
Exactly. So that now that helps the prospective buyers to know beforehand what they are dealing with. You know, before you can even go and inspect, you know already on paper that this property has got so much defects, and these are the kind of defects that I'll be dealing with, and stuff
and approximately this is what it would cost to fix. And so if I buy it at this much, but then I need to put this much into fixing this and this and that, then it's not worth it at the end of the day. You've got the information beforehand, so you can make a more informed decision before you even get into your car and waste your time going to look at a place that actually it's not for you.
Exactly. And now that enables the buyer to prove easily that the seller deliberately concealed some of the defects, because you had an opportunity to go and sit down and now start detailing down all the defects, but you conveniently left one of the defects. You understand? So it's easier for the purchaser to go and prove, because before, the food stores was not requiring the seller to do that kind of an exercise. So this law, which was introduced February last year, is now taking care of that in terms of a mandatory disclosure form, which is a big relief for the property market.
Tell me, who now is, okay, I'm the seller, it's my responsibility to fill in this form with all of the latent defects in my place. Obviously, it needs to be conducted. I could be clueless when it comes to this kind of thing. I don't know about plugs or damp or whatever. I have no clue. Who is the regulatory body when it now comes to, or who am I getting to come and help me to figure out what all of these defects are?
The estate agent, the property practitioner. So the act compels the property practitioner to take you through that exercise. And the property practitioner, if they do not do that, they can be held accountable by the Property Practitioners Regulatory Authority, the PPRA. I think it was previously called the EEAB, something like that. Yeah. So they know they wouldn't do such kind of a thing. They would make sure that they take you through that exercise, and before they go and market the property, there is a mandatory disclosure form fully completed and signed.
But if they ask me if there's a faulty plug and I don't know anything about plugs, and then I say, I don't know.
But you living in the property?
Maybe it's my holiday home. I only go there in December.
Look, if you live in the property, you would ordinarily know. But if you don't live in the property, you obviously wouldn't know. Now, remember, the food stores principles requires you to have the knowledge. If you don't have the knowledge and you can prove that you did not have the knowledge of such a defect, then you gain protection from the food stores. But if we can gather from the facts and the circumstances of the matter that you actually did know, then you are in big trouble.
And you're just a scam artist and not a forgetful somebody who doesn't know anything about their property.
Exactly.
Okay. What are the most common disputes that you've seen in this kind of situation between a buyer and a seller?
Usually when the buyer moves in. That's where issues start.
Obviously, because now you can see all of the things that are wrong.
The latent defects, especially, I'm trying to switch on the oven, but the electricity trips. Now I'm trying to open the taps. I see the pipe is leaking. Yeah. That's when
the water is brown.
Exactly. The problem starts there. That's why in my article, I'm saying these problems usually come to surface only after they've moved in. But is there something you can do? Yes. Make sure that you properly inspect the property as the purchaser. Don't just rely on the mandatory disclosure form. And make sure that you understand each and every defect as detailed. Sometimes you would lack that expertise to be able to understand some of the things detailed. it wouldn't hurt to get a property inspector who would come with that expertise to say, but I think the geyser is not working properly. You understand? That will help you, because it's not everything that you would know that your naked eye would be able to pick. You understand? So it's only fair to yourself that you hire a property inspector to come and have a look at the property, especially those who are in the business of investments, because they trade from time to time in these kind of transactions, and they get to lose a lot of money if they bought a property and they can't put it to use because of such kind of defects. So it's better for you to pay that 3,000, 4,000, 5,000
for an inspector to come through and have a look,
exactly,
and be able to tell you exactly what it is that's going on in the property.
Exactly. That now helps you a lot, because you don't have to worry about the litigation that you have to go through to sue this person and say Food Stores doesn't cover you and all sorts of things. So it's only fair that you do that exercise.
An offer to purchase is a legally binding document, right?
Correct.
How often do people ask you to get them out of that binding document?
It happens a lot. and that is because people sign those offer to purchases without necessarily having a full appreciation of the details of the offer to purchase. You need to get to understand what those things mean. And the moment you get into the offer to purchase, it is very, very difficult to go out. So I get that a lot.
How expensive is it to get out of an offer to purchase? Because it's not free.
I'll say this much, and you will determine how expensive it is. If you need to move out of the offer to purchase, there is wasted costs that you need to pay the attorneys. There is a commission that you will have to pay the estate agent. That's a lot of money. Remember, that commission would ordinarily be paid by the seller from their proceeds of sale. Now, for example, if you are the purchaser and you want to walk out of the agreement, you'll need to take care of that. It's not the money that you would ordinarily afford. It's usually about 7% or 9% of the purchase price. It's a lot of money.
It really is.
Exactly. So just those two, I'm sure you can tell it's quite a lot of money.
Yes.
Yeah. So it's not even advisable.
But it's been done.
Not that often. Look, some people will just ignore you and try to move out of the agreement swiftly. Sometimes they get away with it, depending on who they're trading with. I mean, sometimes you are saved by somebody who comes and be interested, genuinely interested in the house.
Yeah, makes another offer. So it's like, okay, it's fine. We're not losing anything by you taking yours away. Fine.
They will let you go. But if there is nobody coming, I mean, what are the chances? They will come after you. So it's just not advisable. The advice I can give to the people is they must familiarize themselves with the offer to purchase before they append their signatures. Just before you sign, make sure. If it means taking it to another lawyer to scrutinize it, then let it be. Because anything can go south afterwards.
And it's just so expensive.
Very expensive.
To go back on something because you didn't read it properly, or because you couldn't admit that you don't understand the language or what is being said or what's expected of you.
Absolutely. So
what a waste.
Read it before.
What advice would you give to property owners when drawing up the disclosure form? And what advice would you give to, like me now as the buyer who's going to do the inspection?
All right.
Take an expert with me, first of all.
Absolutely. Try and take an expert with you. I know you don't know if you are ultimately going to buy that house. So sometimes you feel like, why should I pay that 3,000 for a property inspector?
Is that how much it is?
I've seen quotes like 3,000. I'm just not sure how much others would charge, but it's around those figures. And you're ultimately not sure if you're going to purchase it. But if you are really sure that this is the property that I'm looking for and I really want to buy it, I think just get an inspector to look into the property. And for those completing a mandatory disclosure form, I would advise them to use the form provided for in the Act. So this Property Practitioners Act, in its Regulation 36,
Section 67.
Section 67, that's where they're addressing each and everything in and around mandatory disclosure forms. But if you go to Regulation 36, that's where they give you the form, the actual form that you need to follow. So if you follow that one, I think it's well detailed, and it will assist them a long way.
Okay. And then now 37 is the one that says you must fill out this form. It's non-negotiable.
36, yeah. You must fill it in and make sure that it's all in order as provided for in 67.
I suppose you'd also advise people to be fully transparent and honest.
Yes. Let us just be transparent. Let us be honest, because you do not want to sell a house today and afterwards you have sleepless nights, because you don't know when these people would come knocking to say, hey, this is what we found out. You're
always looking over your shoulder every night you go to sleep.
You want to have
a
peaceful
the mold?
Exactly. So just keep it simple. Be honest, be transparent, disclose everything. If it means you negotiating the price to go down, then let it be, because that's what you usually come to,
Yeah.
Just negotiate the price to say, okay, it will take you 50K to fix this defect, so let's take it down to 850 instead of 900K.
Yeah. Okay, before I let you go, someone looking to buy in 2023, what advice would you give them?
The very same advice.
Don't do it.
Do it. Just follow the right channels. Make sure that there is a mandatory disclosure form before you sign.
Do you really think we should be buying homes in 2023?
Why not?
In this economy.
Where are you going to be sleeping? We need homes.
We do.
And I am an attorney. If you guys don't go out and take bonds and buy homes,
you won't have a home.
I wouldn't be able to put bread on my table.
Okay, so that's why you want people to buy homes.
They should go out there and buy homes. And there was a tax relief that was introduced by the Minister of Finance when they gave the budget speech.
Tell me about that.
I think it was the what do you call the transfer duty?
Cost, yeah.
Transfer duty payable to SARS, which was adjusted a little bit. Now I think properties which were 1.1 million or less are free or are exempt from paying transfer duty. I think it's a good relief, and even the brackets going up the sliding scale, it has now lowered a little bit, so people wouldn't be paying as much as they would have paid last year. So I think that's a good thing. They should go out there and look out for the properties that they want to buy for their families.
How do people find you now when it comes to the conveyancing needs?
Yeah, well, they can call us. My direct line is 012-432-6446. And our offices are in Pretoria, Lanewood. We've got offices in Sandton. We've got offices in Durban. We've got offices in Cape Town.
Okay.
So wherever you are, we are able to come and assist you with the property transfer. They can also check out our website. We've got a lot of conveyancers in our practice who are more than willing to assist the people.
Love this for us. Thank you so much.
Thank you very much for the
Section 36 and 37.
Regulation 36 and Section 67 of the Property Practitioners Act.
Okay. Don't forget it, especially if you're a property practitioner, because otherwise you might get sued and lose a lot of money. Listen, that's all I've got for you tonight. This has been the Private Property Podcast. I'll see you on the next episode.